The House will come to order. Prayer by the chaplain.
Gracious God, we give you thanks for the gift of life and for the opportunity to gather safely in this place today. You are the giver of all good gifts and have blessed us so abundantly here in the state of Minnesota. From the very tips of the Arrowhead to the rolling hills of the Buffalo Ridge, from the lakes of northwestern Minnesota to the old-growth forests of the southeast, this is a beautiful and rich state. We are grateful to call this place home. Whether we hail from the countryside, a small town, the suburbs, or the inner city, this is our home, and we thank you for it. We are grateful for the gift of our neighbors and our communities. Keep us ever mindful that our greatest strength lies in striving together for the common good. Save us from the blindness and callousness which prevents us from seeing the common humanity in all who call this place home. Help us to work together for the good of all, striving to provide opportunities for employment, education, home ownership, public safety, health insurance, and political voice for all people. We thank you for the men and women who have chosen to serve the people of this state. Thank you for their courage, their compassion, and their leadership. Thank you for their many and varied abilities. Use them to help govern humanely. Use them to help govern justly. And use them to help govern wisely. Uphold them as they go about the difficult work of building consensus to navigate the difficult issues they must discern on our collective behalf. Imbue them with a sense of collaboration and compromise. Keep them mindful of their constituents whom they represent. Keep the people of Minnesota mindful of these men and women's sacrifices and work on our behalf. They are worthy of our respect. God bless our governor, our senators, our representatives, our judges, and all those who serve in this government on this day and the days to come. Grant us these things according to your gracious will. Amen.
Members, the chaplain for today is the Reverend Tom Jenkins from Mount Calvary Lutheran Church in Eagan, Minnesota. Please remain standing and join me with the Pledge of Allegiance to the flag of the United States of America. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. The clerk will take the roll. The clerk will close the roll. Members, a quorum is present. The clerk will read the journal of the preceding day.
Journal of the House, 88th Session, 2014, 91st day, St. Paul, Minnesota, Friday, April 25th, 2014.
Members, if there is no objection, Further reading of the journal will be dispensed with, and the journal will be approved as corrected by the Chief Clerk. Members hearing no objection, the journal is approved as corrected by the Chief Clerk. Comparison reports. There's a copy of this order of business on each member's desk. If there is no objection, the motions will prevail. I'm hearing no objection, members. The motions prevail and the substitutions will be made. Reports of standing committees and divisions. Members, there's a copy of this order of business on your desk. It's been placed on your desk, and if there is no objection, the reports will be adopted. Hearing no objection, the reports are adopted. Second reading of Senate files.
Second reading, Senate File 874.
Second reading.
Second reading, Senate File 2103.
Second reading.
Second reading, Senate File 2271.
Second reading. Introduction of bills. The following House files have been offered for introduction today. The Chief Clerk will report the House files and give them their first reading.
Introduction and first reading of House Files 3358 through 3363.
First reading, House files 3358 through 3363.
Messages from the Senate.
Message from the Senate. This is the Poppe motion. Mr. Speaker, I hereby announce the passage by the Senate of the following House file, herewith returned as amended by the Senate, in which amendment the concurrence of the House is respectfully requested. House File 2746, an act relating to agriculture. Poppe moves that the House concur in the Senate amendment to House File 2746 and that the bill be repassed as amended by the Senate.
Representative Poppe.
Thank you, Mr. Speaker and members. Yes, the House does concur with the Senate language, and this includes now House File 3203, which Representative Clark Johnson's bill, which deals with some biodiesel mandates and updates that a little bit for a constituent of his. So I'd appreciate concurrence.
Any discussion? All those in favor of the motion say aye. All opposed, no. Motion prevails. The clerk will give the bill its third reading as amended by Senate.
Third reading, House File 2746 as amended by the Senate.
Third reading. Any further discussion on the bill? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. Swatsky votes aye. There being 116 ayes and 0 nays, the bill is passed as amended by Senate and its title agreed to.
Message from the Senate. Mr. Speaker, I hereby announce the passage by the Senate of the following House file herewith returned as amended by the Senate, in which amendment the concurrence of the House is respectfully requested. House File 2090, an act relating to civil actions. Portman moves that the House refuse to concur in the Senate amendments to House File 2090, that the Speaker appoint a conference committee of 3 members of the House, and that the House request that a like committee be appointed by the Senate.
Representative Hortman.
Thank you, Mr. Speaker. Members, this is a bill that addressed an issue of impossible indemnification agreements that design professionals were being required to enter into. We fixed it. The Senate added some language that is not peace in the valley, and so I think we need to go to conference and get rid of the language that they added.
Any further discussion? Seeing none, all those in favor of the motion say aye. Aye. All opposed, no. The motion prevails.
Mr. Speaker, I hereby announce the passage by the Senate of the following Senate files herewith transmitted. Senate file numbers 2336, 2398, 2642, 2718, and 2887. That's it.
Announcements by the Speaker.
Announcement by the Speaker. The Speaker announces the appointment of the following members of the House to a conference committee on House File 2090. Hortman, Scott, and Simon.
First reading of Senate files.
Introduction and first reading of Senate File 2336, an act relating to lawful gambling. Atkins moves that Senate File 2336, House File 2482, now in the General Register, be referred to the Chief Clerk for comparison.
Without objection, so ordered.
Introduction and first reading of Senate File 2398, an act relating to commerce. Halverson moves that Senate File 2398, House File 2598, now on the General Register, be referred to the Chief Clerk for comparison.
Without objection, so ordered.
Introduction and first reading of Senate File 2642, an act relating to gambling. Atkins moves that Senate File 2642, House File 2829, now on the General Register, be referred to the Chief Clerk for comparison.
Without objection, so ordered.
Introduction and first reading of Senate File 2718, an act relating to the judiciary. Hillstrom moves that Senate File 2718 and House File 2687, now on the General Register, be referred to the Chief Clerk for comparison.
Without objection, so ordered.
Introduction and first reading of Senate File 2887, an act relating to transportation. Garofalo moves that Senate File 2887, House File 2849, now in the General Register, be referred to the Chief Clerk for comparison.
Without objection, so ordered. Calendar for the day. The first bill on the calendar for the day is House File 1916. The clerk will report the bill.
House File 1916, on the calendar for today, the third engrossment, an act relating to veterans.
Representative Newton.
Thank you, Mr. Speaker. Mr. Speaker, before I formally introduce the bill, I would like to ask the body to stand and recognize 3 of our women veterans who are present with us today, if they would also stand. Thank you, members. House File 1916 is a bill that authorizes the creation and issuance of a women veterans license plate. It's similar to the 15 other license plates that we have, symbolizing various periods of war or service medals. This women's license plate simply recognizes the service of 29,000 Minnesota women who are veterans of the armed forces. This is not a vanity license plate. It's a plate that provides a degree of gender equity for our women veterans. They tell me they're tired of driving their car bearing a Vietnam veteran license plate or Iraq veteran license plate, pulling up to a stop sign and having someone come up next to them and say, thank your husband for his service, when they in fact were the person who served. these soldiers, Marines, sailors, and members of the Air Force simply want to be recognized for who they are. Proud women veterans. Members, I ask that you support House File 1916. Thank you.
The clerk will give the bill its third reading.
Third reading, House File 1916.
Third reading. Any discussion of the bill? Representative Detmer.
Yeah, thank you, Mr. Speaker, and members. Again, Representative Newton, thank you for bringing this forward. It's been a couple years in the making, and I ask the body to please vote for this. A green vote. Thank you.
Representative Earhart.
Thank you, Mr. Speaker. I just wanted to add my congratulations to the women up there that have pushed this and to Representative Newton. I remember going, when I was in the service, there weren't many women around in uniform, but at the commissioning of the USS Minnesota, I think half of the sailors there were women, and it gives an opportunity with the, I think there's 39,000 women veterans, something like that in Minnesota now. This is a good start for them. Congratulations.
Representative Howe.
Thank you, Mr. Speaker. And members, as a former commander of a 250-member unit, 53 members of that unit were women. And if they want to be identified, I believe that they have every right, and we should give them the opportunity to put that on their plate and to be acknowledged that they served. So members, I urge a green vote.
Seeing no further discussion, the clerk will take the roll on the bill. Clerk will close the roll. There being 118 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is Senate File 2245. The clerk will report the bill.
Senate File 2245, the first engrossment, an act relating to public beaches.
Representative Freiberg.
Thank you, Mr. Speaker. A tragedy led me to introduce this bill. Nearly 2 years ago, a 6-year-old boy, Tony Martin Kane, drowned in Worth Lake in the district I represent. His mother contacted me to see if something could be done legislatively to help prevent future tragedies from occurring. One of the things we discovered while researching the issue of safety at public beaches was that under state law, lifeguards at public beaches are not required to have any training. Lifeguards at public pools, on the other hand, are required under state law to have CPR training and to be certified by the Red Cross or a comparable organization. But there are no comparable requirements for lifeguards at public beaches. So this bill would make a simple change to the law, requiring lifeguards at public beaches to have the same training as those at public pools, namely that they be certified in CPR, have a Red Cross or equivalent lifeguard certification, and that they be responsible for the supervision and safety of people swimming at the beach. It does not actually require cities or counties to have lifeguards present, but says that if they are present, they have to meet these minimum qualifications. Many cities and counties already require their lifeguards to have sufficient training. There was, in fact, a trained lifeguard on duty at Worth Beach the day Tony drowned, but Tony's mom and I felt that it was important to set a statewide standard for lifeguard training at public beaches. We worked with the League of Minnesota Cities in drafting this language, which mirrors the language already in state law for public pools, and it is supported by the American Red Cross. I urge a green vote, and thank you for members' consideration.
The clerk will give the bill its third reading.
Third reading, Senate File 2245.
Third reading. Representative Swedzinski.
Thank you, Mr. Speaker. Just would the author please yield?
He will.
Yeah, I appreciate you carrying this bill, Representative Freiberg, but are there any groups or organizations within the state that are going to be exempt from this?
Representative Freiberg.
Thank you, Mr. Speaker. Representative Swazinski, I'm not sure if you mean any organizations operating privately owned beaches that would be exempt. This only covers beaches operated by a political subdivision. It does not cover beaches operated by the state, which there are only 3 is my understanding, and they already have training requirements in place, nor does it apply to beaches owned on private land, if there are any.
Representative Swazinski.
Thank you, Mr. Speaker. So we're going to be passing state law that does, at the end of the day, does exempt state-owned beaches.
Representative Freiberg will yield. Representative Freiberg.
That is correct. As I mentioned, thank you, Representative Speaker, Representative Swazinski. As I mentioned, there are only 3 state-owned beaches, and they do already have these requirements in place.
Representative Swazinski.
Thank you, Mr. Speaker. Even though, I understand that they have these policies in place themselves, but is there any instance where any of the subdivisions do not have these policies already in place? I mean, you're saying the reason why you're exempting the state is because you already have these policies in place from a state, from a DNR perspective. Are there any, from any of these subdivisions that have lifeguards right now not have these policies in place that you've been able to find?
Representative Freiberg.
I'm sorry, I'm not sure I heard all of that. I should thank you, Mr. Speaker, and Representative Swazinski. I'm not sure I caught all of that. It could well be the case that many cities and counties around the state already do have these requirements in place. I suspect that most do. As I mentioned, there was a lifeguard on duty the day Tony drowned. And this does not require any city or county to actually have a lifeguard in place. It just says that if they are present, they have to meet these minimum requirements.
Any further discussion? Representative Drazkowski.
Thank you, Mr. Speaker. Would the author yield?
He will. Representative Drazkowski.
Thank you, Mr. Speaker. Representative Freiberg, still trying to understand from what I thought I heard, and very much a tragedy that happened in your district, and very difficult to hear those circumstances, and I think our hearts go out to your constituent, and we have tragedies like this that happen in life in other parts of Minnesota too. Not to lessen the severity of what happened there, but it sounds to me, from what I understand, that your constituent would not have been saved by this additional mandate. Is that did I hear that properly?
Representative Freiberg.
Thank you, Mr. Speaker, and Representative Drazkowski. Yes, that is correct. As I mentioned in my opening statement, the goal of this was not to specifically address that situation, just to provide a floor for cities or counties that choose to operate a beach for training requirements. I did explain this to Tony's mother, and we both felt that it was a gap in state law and that it was still an important thing to address, and she wanted to move forward with this.
Representative Drazkowski.
Thank you, Mr. Speaker. Thank you, Representative Freiberg. That's what I thought I heard. So, members, we have before us a bill that would not even have helped in the situation that is being used to bring it forward. And I think it's important for us to remember, members, that it is people and the good nature of people that help people in situations like this. It is not a false sense of security brought forward by yet another law, another mandate placed on our communities in Minnesota. And members, I would argue that bringing this bill forward may actually decrease the amount of lifeguard coverage that we have on our beaches throughout the state, because you will see communities that will have a choice at that point that will decide, do we continue with the lifeguard regime that we have in front of us now, which might not meet the requirements in this bill, or do we pay for the additional cost to meet the requirements of the bill? And in some of those cases, I will submit to you, members, some of those communities will decide, we will just post a sign that says swim at your own risk, as one of their decision points that they make in response to yet another unfunded mandate that does nothing good for the state of Minnesota. For that, Mr. Speaker, I thank you.
Representative Johnson.
Mr. Speaker, will Representative Freiberg yield for a question?
He will. Representative Johnson.
Representative Freiberg, I'm just wondering if you know what the qualifications are to be a lifeguard.
Representative Freiberg.
Thank you, Mr. Speaker and Representative Johnson. The requirements vary from jurisdiction to jurisdiction. I have several job postings here in front of me. So, for example, in Washington County, the employment criteria state that lifeguards must be at least 17 years of age, able to read, write and follow written and oral instructions, must have own means of transportation, must possess a current lifeguard training certificate issued by the Red Cross, current CPR and first aid certificates. There's some minor variation between the requirements from jurisdiction to jurisdiction, but generally they follow that sort of pattern. The bill before us would only require that they have certification from the Red Cross or a comparable organization. For example, the YMCA offers lifeguard training. The Red Cross certification is the one I'm most familiar with. That requires 25 hours of training. And then the second requirement in the bill before us is that they be trained in CPR and also that they be responsible for the supervision and safety of people at the beach.
Representative Johnson.
Mr. Speaker, Representative Freiberg, I'm going to clarify that question if that's okay. What I was questioning is what are the qualifications to become a lifeguard certificate. For those that don't know this, I was a lifeguard. To become a lifeguard, you have to have first aid training. You have to have CPR training, both adult and youth. I have had the unfortunate circumstances of doing CPR on a 2-year-old drowning victim. It's horrible. It affected me dramatically. This bill requires a lifeguard certificate, and on top of that, CPR training, first aid training, which is part of your lifeguard certificate. There's redundancy in this. But what concerns me the most about this bill is what Representative Drakowski brought up. I believe because of this, most cities right now, or counties, if they have a public beach, they decide to put lifeguards out, their insurance companies, for liability reasons, already require them to have trained personnel on the beaches. What this bill is going to do, and I have a habit of looking at unintended consequences. They're going to be putting up signs saying, swim at your own risk, no lifeguard on duty. We've already increased the cost of some of these cities and counties with the minimum wage increase. They're going to be looking at ways to cut costs. And with this extra requirement and putting it in statute, it's going to create other issues. With it saying that person is responsible for supervisory and the safety of the public, if an employee happens to be on the beach when something happens, he's an employee of the county or the city or an employee of that beach, although not a lifeguard, is he going to be, that jurisdiction, you're going to get into trouble because that person who is employed to do something else is not certified in first aid training. By doing this, I think it's going to create other issues, and we're going to have less trained people on the beaches protecting our children.
Representative Liebling.
Thanks, Mr. Speaker. Members, I am frankly really surprised and appalled at the direction of this discussion and debate over this very simple bill. My goodness, do you want to take your child to a beach and have a lifeguard there and then, God forbid, find out the lifeguard doesn't know how to do CPR when your child gets into trouble? Does anybody on this floor think that would be acceptable? My goodness, members, this is a very simple bill. It's a cheap requirement, and if municipalities are so short on funds that they can't afford to have a lifeguard get CPR training, maybe it would be better to say swim at your own risk, because then at least the parent is on notice that there isn't somebody there to take care of a situation. But if you've got a lifeguard standing there then I think people pretty much assume that that lifeguard knows the basics. And this bill simply provides that they have to know the basics. I think it's a really minimal requirement, but gee, members, if you think it's really onerous, you can vote no. Vote no against having lifeguards know CPR. I think you'd have a tough time explaining that to your constituents.
Representative Albright.
Thank you, Mr. Speaker. Would the author of the bill rise for question?
He will. Representative Albright.
Thank you, Mr. Speaker. Representative Freiberg, in your opening comments, you made reference to the fact that this pertains only to beaches. I'm just wondering, in the context of swimming beaches right now, if it is a requirement or a provision that they declare or make prominent a sign that suggests that swimmers using or people attending those beaches swim at their own risk. Could you answer that?
Representative Freiberg.
Thank you, Mr. Speaker and Representative Albright. I don't believe that is a requirement, but I can double check on that. As I mentioned in the opening, this bill was drafted with the assistance of the League of Minnesota Cities, which I know insures several cities from liability risks, which was raised here, so it was drafted with that in mind. And it mirrors the language that's already in place for publicly owned pools. The language is virtually identical to requirements in there for publicly owned pools, and I know there have been a couple drownings recently in pools, which in my mind at least highlights the importance of training for lifeguards. Thank you.
Representative Albright.
Thank you, Mr. Speaker. And Representative Freiberg, given the context that a public beach would have the option of, in a local municipality, either posting a sign on a steel post saying swim at your own risk, or if they felt so inclined, it would be their opportunity to hire a certified, and I'll use the context of a Red Cross certified lifeguard, given there is a registrar that tracks those people that have taken that certification. So is the bill mandating, or is it giving the opportunity for the municipality to choose one or the other?
Representative Freiberg.
Thank you, Mr. Speaker. Representative Albright, the bill does not require a lifeguard to be present at any publicly owned beach. It just says that if there is a lifeguard present, it has to meet these minimal requirements, which I think comports with the expectations of many parents who may have children swimming at that beach.
Representative Albright.
Thank you, Mr. Speaker. So let me just be clear for the body, as I would understand it, and I'm just trying to clarify. It does not mandate that a municipality hire a lifeguard at a public beach if they have a steel post and a sign that says swim at your own risk. But they do have the opportunity, if they are so inclined, to hire a certified lifeguard which would replace that sign. Is that correct?
Representative Freiberg will yield. Representative Freiberg.
Thank you, Mr. Speaker. Representative Albright, the bill does not require a lifeguard to be present. And actually, while you were asking the question, I just discovered the rule currently in the administrative rules relating to warning signs, and it only relates to publicly owned pools, so I don't believe there is a requirement for warning signs at beaches. I think, in my mind, it seems like perhaps there should be. So if you'd like to work on a bill that would require that in the future, I'd certainly be happy to work with you on that.
Representative Albright.
Thank you, Mr. Speaker.
Seeing no further discussion, the clerk will take the roll on the bill. Clerk will close the roll. There being 110 ayes and 10 nays, The bill is passed and its title agreed to. The next bill on the calendar for the day is Senate File 2571. The clerk will report the bill.
Senate File 2571, the first engrossment, an act relating to public safety.
Representative Slocum.
Thank you, Mr. Speaker. Senate File 2571, House File 2928 is technical amendments to criminal vehicular homicide or operation statute. First, I want to thank my colleagues who serve on public safety and judiciary for approving this bill, and in particular, the co-authors, Representatives Cornish, Rosenthal, and Uglum. I hope I pronounced your name right, otherwise I'll be over to apologize later. The Senate approved this bill 66-0. The purpose of the bill itself is to enable the judicial branch to transmit necessary information for more efficiency to the Driver Vehicle Services Division of the Department of Public Safety. This bill addresses limitations of the judicial branch and the Division of Vehicle Services information systems and an unintended consequence of the reformatting of the criminal vehicular homicide or operation statute that was done in 2007. Currently, the courts can electronically transmit the charge filed for the crimes of criminal vehicular homicide or operation to the Departments of Vehicle Services. However, the Department of Vehicle Services cannot accept electronically the penalty provisions, which indicates whether there's been a death or a degree of injury. The period a driver's license is suspended or revoked for a conviction of Minnesota Statute 609.21 depends on whether there was death or injury. This legislation will separate the two offenses into two separate sections to enable the courts to send a single offense code in the notice of conviction to the Department of Vehicle Services and eliminate the need of court staff to use a manual workaround. The court and the Department of Vehicle Services believe this is the most cost-effective way to transmit the necessary information to the Department of Vehicle Services. Also, separation of the two offenses will allow for more accurate information being provided in court calendars. Thus, judges, court staff, and the public do not mistake a criminal vehicular operation case for a more serious criminal vehicular homicide case. I would appreciate your green vote. It's a simplifying bill, and I'm open for questions.
The clerk will give the bill its third reading.
Third reading, Senate File 2571.
Third reading. Any discussion? Representative Holberg, thank you.
Thank you, Mr. Speaker. Will the author yield?
She will. Representative Holberg.
Thank you, Mr. Speaker. I'm curious as to what the effects of this legislation will be on those situations that have already occurred. Will this fix this for prior convictions? Will the records be updated for the people that have gotten caught in this inadvertent problem?
Representative Slocum.
Thank you, Mr. Speaker. Representative Holberg, there's no substantial changes to the crime law, just purely technical restructuring. The old language is used for prior convictions to enhance the penalty for current criminal charges. There is no, in the restructuring that is in this law, there is no retroactivity.
Representative Holberg.
Thank you, Mr. Speaker. And Representative Slocum, I understand all that. What I'm talking about is how the record will be reflected in their driver's license information. So right now, where they're not able to separate it and it shows all of that as one offense category for previous convictions, will those people have the benefit of this new way of reporting?
Representative Slocum.
Mr. Speaker, for offenses going forward, the law would cover this, the dividing by vehicular homicide and on the licenses, but it is not retroactive at all. They will not, at this point, have that opportunity.
Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 120 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2728. The clerk will report the bill.
2728, an act relating to public safety.
Representative Simonson.
Thank you, Mr. Speaker and members. This is a bill from DVS that does a couple of different things that I'll just briefly talk about here. Right now in current law, there's a provision for moped permits between the ages of 15 and 21, and current law allows for a 1-year motorized bike operator's moped permit. This bill would strike that provision and replace it for a moped operator permit to be valid upon issue until the age of 21. So in theory, it makes it a little bit easier for the user. The second thing that it does is it touches on the subject of commercial driver's license learner permits. We have that provision in current law. Federal regulations have required us to issue a tamper-proof commercial learner permit, and there is, of course, a fee associated with that. So this bill would provide for a $2.50 fee to cover the cost of the card and the staff time to complete the driver's license check and establish the holder in the information system. The third piece that this bill does is it talks about federal conformity, and essentially it states that the provision would clarify that issues related to record keeping and license holder disqualifications, when there's perceived conflict, that the federal law would supersede the state law. And that, with that, Mr. Speaker and members, that's kind of the essence of the bill, and I stand for questions.
There is an amendment at the desk. The clerk will report the amendment.
Keel moving to amend House File 2728 as follows. The amendment is coded A1.
Representative Keel.
Thank you, Mr. Speaker. And Representative Simonson and members, I just happened to a couple of weeks ago get a call from a custom combiner that goes down to Texas and harvests all the way to Minnesota and is actually a down-the-road neighbor. And he expressed to me that it would take over 6 weeks for his employees to get their CDL license in order to haul the combines down to Texas. Well, after some investigation, I discovered that, the department is in need of some people. And so this amendment suggests or tells the commissioner to add some employees and require that our license be able to be, our students and our businesses be able to apply for a license, do their driver's test within 14 days. Having some questions about it, we did a little finance questions on it and found that driver services do have about $4 million in their coffers, and even if every department, every site actually hired one new person, it would be about $815 $815,000 for those people. So I guess I know there's some angst about trying to push this along, but I really think it's important. I've heard parents struggling with students that are finally 16 and they've passed all the requirements and they are able to take the test, have to wait quite a while. It makes it difficult for them to actually apply for a job. I know in the agricultural world we look forward to our students being able to drive so that they can also help us in the field work, and this becomes a problem also in that area. So we'd like to encourage our Department of License to keep it to 14 days and be able to provide those tests. No guarantee they'll pass them, so they might need a little more time. Thank you.
Representative Simonson.
Thank you, Mr. Speaker, Representative Keel. And Mr. Speaker, on the A1, I'd request a roll call.
Roll call has been requested. Seeing 15 hands, there will be a roll call.
Thank you, Mr. Speaker. Representative Keel, I like your amendment. I think it makes good sense. I think it's good policy. At first, I was a little bit concerned and reluctant because I thought maybe it should proceed through the committee process and be vetted, but this is an amendment that makes good sense. I think 14 days is a reasonable time period, and when sometimes I forget about the agricultural world, but the points that you brought up make very good sense, and I think that if there's something that we can do to add some FTEs in appropriate places to speed up that process, I think it's good for business, I think it's good for commerce, I think it's good for Minnesota. So, members, I would encourage a green vote.
Any further discussion? Seeing none, the clerk will take the roll on the amendment. Clerk will close the roll. There being 121 ayes and 0 nays, the motion prevails. The amendment is adopted. The clerk will give the bill its third reading.
Third reading, House File 2728 as amended.
Third reading. Any further discussion on the bill? Representative Simonson.
Thank you, Mr. Speaker. Members, I would just encourage your support. It's a good bill. Thank you.
Clerk will take the roll on the bill. The clerk will close the roll. Wagenius votes aye. There being 114 ayes and 7 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 2755. The clerk will report the bill.
House File 2755, an act relating to corrections.
Representative Paymar.
Thank you, Mr. Speaker and members. House File 2755 is one of the unsession bills that we've all heard. The Corrections unsession bill repeals outdated and redundant statutes, obsolete references to a number of boards and other activities at some of our facilities at the Department of Corrections, including in Sauk Center and Red Wing, and there's nothing controversial in the bill. There's 10 repealers, and I'll save Representative Pepin the time and just say that there is, as far as I can determine, there's no financial benefit to this particular unsession bill. But I think it's a good thing for us to get rid of this obsolete language in our statute books, and I would ask for your support.
The clerk will give the bill its third reading.
Third reading, House File 2755.
Third reading. Any discussion to the bill? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There are 122 ayes and 0 nays. The bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2722. The clerk will report the bill.
House File 2722, an act relating to family law.
Representative Mahoney.
Thank you, Mr. Speaker and members. House File 2722 is the product of a couple years of collaborative conversations and dispute resolution. And before I go any farther, I'd like to thank Representative Norton, Representative Lane, Representative Peggy Scott, who attended hours of conflict resolution and in this talking about this particular issue. For many of those that have been here for a while, they know this is an issue that comes up every couple of years. And it's a very touchy, in a bad way, kind of touchy, sensitive issue. How we, in a divorce or in and parents break up, how they deal with their children. A couple years ago, we passed a bill calling for 35% parenting time for both parents, and it was pocket vetoed, with a call for all groups to get together and have a conversation and talk and try to come to agreement. So I want to make sure that everybody knows that we took the governor to heart. We had all the major family law groups represented in this group. We had the judges represented. We had a person or two from the University of Minnesota in child psychology, not representing the U, but representing himself. We had the Minnesota Coalition for Battered Women. We had legal aid. And I want to give a special shout out to a good friend, Molly Olson, at the Center for Parental Responsibility, who's been working on this issue for many, many, many years. So we all agreed that we would bring only that which we all were comfortable with and agreed to. So this bill has been worked out probably more than any bill I've ever worked on. And does it get to the end product that we all want? Not quite there. But what this bill does represent is that people who have worked on this issue on either side not only didn't talk to each other, but glared at each other in this building. Would cross the hallway so they didn't have to breathe the same air in many respects. Today we talk to each other. We may not like what we hear, but we actually listen and hear their concerns and they hear ours. So it's a real big step. And what this bill does, this bill, House File 2722, puts into law that there is no presumption for or against joint physical custody, except when domestic abuse, as defined in law today, has occurred between the parents. The court, there's many factors that they have to use, and in this particular section of law, what we have this bill do is clarify that they cannot use only one to the exclusion of all the others. You have to take into consider all of them. So if somebody fails on one, they still have a shot on some of the others to make that case that they can and should be a good parent and given the opportunity to be a good parent. It also clarifies that when you disagree, now I didn't realize this, but when parents disagreed over joint physical custody, it could be used against you in the sense that you as parents can't get along, so I as the judge, that's a scary thought by the way, I as a judge, will decide that I'm only going to give custody to one. They can't do that anymore with this bill. And the other parts to this bill, and I'm just going to read this. The court, when issuing a parenting time order, may reserve a determination as to a future establishment or expansion of the parent's rights. In the event the best interest standard sets forth in subdivision 5, paragraph A, shall be applied to the subsequent motions. There's something that was said on the floor a couple years ago is that we're asking people to make decisions about their children, they're probably their most precious thing, at the time when they are the angriest. And a wise judge, whether she's in a hurry or not, understands that this is the angriest moment. And now can say, you're coming back in 2 years to have another conversation to see if this 25% is the exact right deal for you. Because people change. And temper's cool, I should phrase it that way. The other piece that I'm very comfortable with and glad to have finally gotten this in there is that in the consideration of a child's best interest includes a child's changing development needs. We all understand that a child at 3 has entirely different attitudes, needs, and outlook on life at age 13. What this does is the judge can put that into their decision. And this one, the last piece of this bill, a modification of parenting time, which increases a parent's percentage of parenting time as an amount that is an amount between 45.1 to 54.9, is not a restriction on the other parent's parenting time. That's a really very minor piece that a judge has put into play, and everybody agreed that we should just clarify that and say that it's not a restriction on the other parent's parenting time if they go outside of that limit. So with that, members, I again want to thank Representative Norton, I want to thank Representative Scott and Representative Lane. This would not have happened without all of these people showing up to multiple meetings. And I want to thank those that I know have great concerns about this and wanted much more, who did not offer amendments to this bill today, because we all agreed that we would only bring forth language that the group all agreed to. So with that, members, I'll stand for questions.
The clerk will give the bill its third reading.
Third reading, House File 2722.
Third reading. Any discussion of the bill? Representative Lane.
Thank you, Mr. Chair. I just want to say Representative Mahoney's done an excellent job of explaining this bill, but I need to speak out loud for all of those of you who have been on the opposite side of Representative Mahoney over these last many years, because that's where I have been. This is a very contentious issue, and it has moved now into this collaborative discussion process, which has been absolutely marvelous. We've started with shared principles, and nothing comes out of it that isn't based on shared principles. It's an excellent way to move on a very, very contentious issue. One of the things I'll mention is that the domestic violence groups are in support, and they're on board with this particular bill. And also, one of the things that I had concerns about originally was, like, for instance, an if infant. And Representative Mahoney has mentioned even you can have a different need for a 3-year-old than an older child. But before, the divorce proceedings were based on, had a finality to them that made it very, very difficult. So what you needed to do with an infant was the same as you needed to do with a 17-year-old, and that was absurd. Now there's that flexibility built right in. So this is very good. I want to also say that this particular method of collaboration is supported by the Office of Collaboration and Dispute Resolution that we passed off this floor last year or a few years ago, I can't remember. Anyhow, it's an excellent, excellent process to work on things that are this contentious, and I hope for good things to come yet. Thank you.
Representative Hertas.
Thank you, Mr. Speaker and members, and I rise also in support of this legislation. Representative Mahoney, thank you very much for the work and the other co-authors have done on this legislation. This is an issue I've received quite a bit of correspondence on from constituents in my district.
And it has long been held a primary responsibility of the father to significantly contribute to the assets and resources in situations like this when it occurs. But obviously parents go to court because they don't agree on custody issues. And thank you very much for what you're doing here, and I think this is definitely a step in the very good direction, positive direction. Thank you very much.
Representative Howe.
Thank you, Mr. Speaker, and thank you, Representative Mahoney and Representative Scott, for working on this bill. I'm one of those that wanted to bring forth an amendment to this. I fully support what's done. I just thought we should do a little bit more. I have a constituent that I'd like to get into the child support piece of this family law, because I tell you what, I've got a young man that makes $60,000 a year, yet only takes home $1,000 every 2 weeks. He's supporting 2 ex-wives with two children with each ex-wife. I think to say that he's learned a little bit, I would say I would be minimizing the thing. But here's we need to make this so it's not only he takes care of his kids, but he needs to be able to work and earn a living. Right now, I think he's getting forced to the point where he's thinking about giving up and not having an income. And that's a real travesty to someone that's actually working hard and making a good living but doesn't take anything home. So I think we could take some of the same things that we've done in this and apply them to that, and I think we could have some success. So I applaud this effort. I think this is a definite step in the right direction, and thank you, and I urge a green vote.
The member from Anoka, Representative Scott.
Thank you, Madam Speaker, and thank you, Representative Mahoney and the other members of our collaborating group. It has been a long process, and we're getting ready to enter into phase 2 of this. As you know, I carried House File 322 a few years ago, and was very disappointed to see the governor pocket veto that. And quite frankly, I was very skeptical when he called me and told me that he wanted all players to come to the table. And indeed, that is what has happened. And so I'm very grateful for that. Folks that we would often in the past say, "What do you not like about this bill? Give us your feedback," and it was crickets. But now we're sitting across the table from one another and have developed a great deal of trust and respect. As most of you know, this bill, in my opinion, doesn't go far enough yet, so we're still working on that. And just to bring to light that this issue is still at the forefront of many people's lives, I was contacted last week by a constituent whose son is going through a divorce, and the mother has primary custody, and the children, the mother's siblings are contacting the father, calling them, saying, "She's drunk right now. Please come and get the kids. Don't let her drive. She's drunk." This woman is, the mother in this case, is an alcoholic and shouldn't really have custody of those children because they're not safe in her presence. And the problem is the judge doesn't see it that way and still has allowed her to have custody of the children. They've even gone to the extent of going to the school saying, what do we do? They've gotten them in touch with child protection. Their hands are tied. And so these children are really at risk. And so I just want to bring that up as an anecdotal story to, I guess, continue to let people know that this issue still is a problem. There have been some strides made in some of the family courts across our state, but not nearly enough. There are still a lot of children that are being alienated by no choice of their own from one or the other of their parents. And we're not doing those children any favors in many cases. They need the active participation of both fit, loving parents in their lives when that is possible. So with that, I would just encourage a green vote. I would encourage you all to stay in contact with the constituents that contact you. Tell them this is a work in process and that we are making some moves in the right direction. And with that, I would hope that some of the other folks on the floor here would pipe up and tell some stories. Thanks.
Representative O'Driscoll.
Well, thank you, Madam Speaker.
Every child is entitled to their parents and a loving and supportive family. Unfortunately, the way that the society is working these days, we see about 50% of marriages end in divorce. And it's very unfortunate for those children that that happens. If we can allow those children to have access to both of their parents, that's extremely important. It's extremely important for girls to see a strong father figure. It's important for boys to see a good, loving, caring mother and a good, loving, caring father as well. This bill, as Representative Scott said, doesn't go as far as it needs to or as far as it should, but it is the first step on many steps to being able to treat the kids who are the real victims in a divorce. Everyone in this chamber knows that of a situation where a parent would use the child as a weapon against the other spouse or the ex-spouse. Totally unacceptable. Absolutely, totally unacceptable. I'd like to thank Representative Mahoney, Representative Lane, Representative Scott, Representative Norton, and others. This bill is long overdue. Tomorrow starts today in raising these children. And we need to make sure that we give these kids every fighting chance they have and that we can. And that means giving them both parents whenever possible on an equal basis. Just because mom and dad don't get along doesn't mean that they don't love the children equally as well. Thank you, Madam Speaker, and I encourage a green vote.
The member from Olmsted, Representative Liebling.
Thank you, Madam Speaker. Members, I also support the bill. I also want to thank those who've worked on it. For every story on one side, you can get another story on the other side. That's the problem with this issue. It's really a difficult one because we hear some people think that dads always get a bad shake, but then you hear other people telling you that moms always get a bad shake. I actually really like the bill, and of course no bill here is the end of the work. But I especially like the portion of it that allows consideration of a child's changing needs. I think that's something that's been needed for a long time, and I'm not going to be a bit surprised if I see the board light up all green, and I hope I do.
Any further discussion? Seeing none, the clerk will take the roll on the bill.
Madam Speaker.
I'm sorry, the member from Anoka, Representative Runbeck.
Thank you very much, Madam Speaker. I would like to say a thank you to Molly Olson and her work with the CPR group. I got to know her a dozen years ago, and just can't believe the kind of fight she's had to put up for all of these years, and to keep the non-custodial parents empowered, and to make them feel empowered when sometimes they feel like it's such a lost cause to change our laws. I still hear from a constituent from when I represented Blaine, and that's more years ago than I want to remember. But he is now a senior. He's ill and infirm, and he still doesn't have contact with his kids. It's been a lifelong battle, and he still is alienated. So our system does an injustice. We need to keep working.
Any further discussion? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There being 122 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2925. The clerk will report the bill.
$29.95 on the calendar for today, the second engrossment, an act relating to public safety.
Representative Lesch.
Thank you, Madam Speaker. Members, House File 2925 is an important bill. I
as well as many of you, are very proud of our state's criminal justice system. It's a system that delivers justice with fairness and integrity, but it is composed of people like you and me, which means it is not perfect. And sometimes the system makes mistakes, and injustice occurs because of that. There are two individuals that many of you who sat on the committees through which this bill passed that you heard from, Kuo Fung Lee and Michael Hansen, who spent years in prison, and they were later exonerated. This bill is an effort to compensate them for the time that they spent in prison with no official apology for the wrongs that occurred to them, no money for housing, transportation for their families. Kuo Fung Lee had a child, his youngest child, that was born while he was in prison. They didn't have the opportunity to advance themselves in their careers or get better educated in order to support themselves and their family. So this bill is an effort to correct that. It sets up a two-tier system whereby first you are exonerated, and second, a panel determines the level of compensation to which you are entitled for your time that you've spent in prison. It's a floor of $50,000 per year for each year you spent in prison, and $25,000 per year for each year that you spent on supervised release. Let's say you did 7 years in prison, and you shouldn't have, and you did another 4 years on supervised release, laboring as a short order cook or a janitor when you couldn't get a job in your chosen profession as engineer, for example, because of your outstanding conviction, which later turns out to be unjust. That's what the bill does. Madam Speaker, I do have an amendment that I would offer.
There's an amendment at the desk. The clerk will report the amendment.
Lesch moving to amend House File 2925, the second engrossment as follows. The amendment is code at 1143.
Representative Lesch.
Thank you, Madam Speaker. Members, the A14 amendment clarifies many of the sections of the bill and has some cleanup language. There are two primary substantive changes. One substantive change is that it changes the standard of proof from preponderance of the evidence, which is essentially a teeter-totter, you get more evidence or not, to clear and convincing, which is a higher standard. Not as high as reasonable doubt, which we use in criminal cases, but it forces the person to a higher standard of proof in order to gain the compensation under this bill. This amendment was offered by the county attorneys. The bill itself had substantial momentum and probably would have passed this body and the Senate without this amendment. That said, members, in passing this bill, we are not looking to point fingers at who made the mistake. Prosecutor, police, judge, defense attorney, whomever. We're not looking to point fingers. But as you can imagine, the county attorneys do have some apprehension about that. And as comfort language in the bill, we had offered the clear and convincing standard. I expect that out of the Senate, we will have the preponderance of the evidence standard come out of that bill. So I expect that in conference committee we will have a thorough discussion about the county attorney's desire to have it be clear and convincing, as opposed to the Innocence Project, their desire to have it be preponderance of the evidence. As you can imagine, individuals, citizens, or whomever who is convicted are innocent until proven guilty. So if we can establish that they were exonerated, it would probably be my preference that that standard be as low as possible, because they're innocent until proven guilty. You shouldn't have to make them take even a higher step to be clear and convincing. But I expect that the county attorneys will have some good arguments for the clear and convincing standard, including the fact that our surrounding states that have this compensation statute in effect, for them the standard is clear and convincing. So I would ask that you pass this amendment, the county attorney's amendment to the bill, and after that we'll have a conversation in conference committee on this. I would note also that it puts in place a cap
of $100,000 per year for time spent in prison, and $50,000 for time spent on supervised release. So with that, I'd entertain questions on the amendment, but please support it, members.
There's an amendment to the amendment. The clerk will report the amendment.
Lesch moving to amend this amendment to House File 2925 as follows. The amendment is coded A6.
Representative Lesch.
Thank you, Madam Speaker. So this amendment is also offered by the county attorney's members, and the reason for the amendment, the secondary and the primary amendments, is because we were in negotiations on this bill all the way up to the deadline on Friday. I said put all the amendments in and we'll take a look at them over the weekend. What the A14-1145 amendment does is it allows the prosecutor, if they do not object to the fact that this person should be exonerated, it allows them to join in the petition and skip the entire first part of the hearing, but the petitioner, meaning the person who was in prison but shouldn't have been in prison, still gets that certificate from the judge. They can go and show their boss for whom they've been flipping burgers, hey, look at this, okay, I'm going to get my old job as an engineer back and support my family. So it makes those two changes. Please support the amendment to the amendment.
Discussion. Seeing no discussion, all those in favor of the amendment to the amendment, please say aye.
Aye.
Those opposed, please say no. The motion prevails. The amendment is adopted. There's another amendment at the desk. The clerk will report the amendment.
Lesch moving to amend his amendment to House File 2925 as follows. The amendment is coded 1145.
Representative Lesch.
Madam Speaker, this is an amendment to the amendment offered by the Innocence Project. It changes the standard back to preponderance of the evidence. In order to facilitate the discussion about that standard in conference committee, I will withdraw the amendment.
Representative Lesch withdraws the amendment to the amendment. We are back on the Lesch amendment as amendment, A14-1143. Any discussion? Seeing none, all those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Peppin moving to amend House File 2925, the second engrossment as follows. The amendment is coded A3.
The member from Hennepin, Representative Peppin.
Thank you, Madam Speaker. I'd like our roll call for this amendment.
Representative Peppin requests a roll call. Seeing 15 hands, there will be a roll call. Representative Peppin.
Thank you, Madam Speaker and members. This amendment was actually Representative Newberger's amendment, and he wasn't able to offer it today, so I'm taking it over. What it does is it limits the amount of attorney fees to 5%. And the reason I would like to see a limit is because there is no limit in the bill language itself, and it's my belief that if a person is exonerated from a crime they didn't commit, then they shouldn't be the victim twice. They should make sure that they get the amount that's due to them, and there shouldn't be some attorney come in and take a percentage that is unreasonable. I know it calls for reasonable attorney fees. However, I think that since there could be a large amount of money with very little work on behalf of the attorney that's provided, since it is determined by a panel, I just think that it's fair to limit the attorney's fees to 5% in this case, as it is different in pretty much any other type of case, since there's an actual panel that decides the amount of money. So, members, I would appreciate your support.
Representative Lesch.
Thank you, Madam Speaker. Members, I'd ask for a no vote on this amendment. In the bill, lines 4.32 through lines 4.34 expressly allows the panel, which makes the determination about damages in this case, to award reasonable attorney's fees. Now, if this amendment were added and the limit of reasonable fees were capped at 5%, you're not going to get very good attorneys working on these individuals' cases for them, which are pretty important. So I think it's properly left up to the panel of experts to determine the amount of the award, which would include the amount of reasonable attorney's fees. Please vote no on the amendment.
Discussion to the Peppin amendment. Seeing no further discussion, the clerk will take the roll. The clerk will close the roll. There being 51 ayes and 72 nays, the motion does not prevail. The amendment is not adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate House File 2925 as amended.
Third reading as amended. Discussion. The member from Hennepin, Representative Hertas.
Thank you, Madam Speaker. Would the author yield for a question, please?
He will. Representative Hertas.
Thank you, Madam Speaker. Representative Lesch, when you were describing the bill, you were articulating some of the rates of compensation given different circumstances, and I used the word compensation, but I would like to clarify, is this an award of damages or award of compensation?
Representative Lesch.
Madam Speaker, Representative Hertas, it's an award of compensation. I use the term damages because that's the universal term used when making awards like this in court, but this is award of compensation.
Representative Hertas.
Thank you, Representative Lesch. I guess I would want to make sure that the intent of the bill and the language with regard to taxation of these compensation is just that it's not taxable, that it is an award of damage, and that it would be precluded or excluded from taxation for purpose of the appellate getting this award.
Any further discussion? The member from Wabasha, Representative Drazkowski.
Thank you, Mr. Speaker, Madam Speaker, and thank you, Representative Lesch. This is a good bill, members. We heard some very compelling testimony in the Judiciary Committee. Two individuals who fall into this exact category who had been wrongly imprisoned by our state government, and those are the type of people, a very limited number of people who this applies to. And Representative Lesch, I think the clear and convincing language is good and will give people comfort as this goes forward. I'd encourage you, Representative Lesch, to consider the attorney fees discussion. I know that you had and others had problems with maybe the construct of the amendment, but if you could take a look at that in conference committee, if it does go to conference, that would be appreciated. But a green vote, members, I encourage. Thank you, Representative Lesch. Thank you, Madam Speaker.
Further discussion? Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 121 ayes and 2 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 2654. The clerk will report the bill.
House File 2654, the first engrossment, an act relating to public safety.
The member from Blue Earth, Representative Cornish.
Madam Speaker, I have an amendment at the desk, A1.
There's an amendment at the desk. The clerk will report the amendment.
Cornish moving to amend House File 2654. The first engrossment is followed. The amendment is coded A1.
Representative Cornish.
Madam Speaker and members, this is a bill of the elimination of part-time peace officers. Now that might sound a little bit controversial or scary when you say elimination of something, but I'll do my best to explain why it's not and give you comfortability.
Back in 1977, Post Board, Peace Officer Standards of Training, came out with a licensing system and a professional training system for peace officers. At that time, I was an Amboy cop in southern Minnesota, and at the time all you had to have was 8 weeks of training from the BCA to become a police officer if you were from a municipality under 1,000 people. If you were over 1,000, then you had to have, you didn't have to have anything. If you were over 1,000, you had to have the 8 weeks certification by the BCA. Since then, a number of very stringent requirements have been put on police, making Minnesota one of the top states in the nation as far as training and professional peace officers. Now, the discussion around part-time peace officers started way back in 1979, and they started putting restrictions on part-time peace officers, capping the number of peace officers and allowing them to work, but work under supervision of a supervisor or a full-time licensed officer, and also the number of hours they could work, and different things like that. And the reason is right now, so that you understand the difference between a part-time and a full-time license. A part-time licensed officer right now doesn't have to have the college or the skills course that a full-time does. We're putting people out there with a gun in the hand and a full power of arrest, detain and arrest you, and with basically 40 hours of training. And what we want to do is change this and eliminate the part-time peace officers and have full-time peace officers left only. Now, there's some people that are saying this will have a local impact. Just keep in mind there's only 175 of the part-time licensed officers spread over the entire state. And when I was chief of police in Lake Crystal, we didn't use part-time officers anymore, and we got full-time officers that work as part-time officers now. And I believe this will have a very minimal impact on your agencies. And there is a sheriff here or a chief there that's complaining, and naturally in any organization, police organization or civil organization, you're never going to get everybody to agree. But the Sheriff's Association does support this move, and the Post Board, the Peace Officers Standards of Training, also supports it with a vote to finally eliminate the part-time peace officer. Now, the good thing about it for the part-time peace officers currently training, they will test you right up until June 30th. And I talked to the post director, and he says there's really no excuse for somebody not becoming a part-time peace officer by the date of this effective date, which we will change with this amendment that's going to be offered, the A1 amendment. The original date was August 2nd, and that was to take care of the part-time peace officers in training, allow them to train and test up until that time. Now, by moving it back to June 30th, the only reason for that was that's when the licenses are renewed, and it caused a glitch in the system if we didn't do it then. So anybody that's part-time peace officer right now in training or training for it can test right up until June 30th. And the part-time peace officers that are currently hired and currently working are grandfathered in until they retire. So if you've got a young officer working right now as a part-time officer, they can keep working until they retire for many years. And the local impact will be lessened because these people aren't going to drop off all at once. They will do it as they retire, and they will be replaced. Now, just so you understand, part-time peace officer and full-time peace officer, that's just a definition of the license. So what I'm saying there is if you have a part-time peace officer quit at a department, a full-time peace officer can come and take their place and work part-time if they wish. And in each case we've had where some people have been worried about in the past, where we've increased training requirements and they've been worried about it, we've always met the quota as far as number of officers willing to fill the job, and I believe we will this time too. I don't believe in any worries out there about not being able to find the number of peace officers that you wish to fill the positions. So the part-time officers that are training right now, they can test, they'll be taken care of, and then they're grandfathered in. The existing officers that are already licensed can work until they retire, And that's about the long and the short of it. Right now, the part of the problem with the part-time peace officers is they can only work so many hours. They have to be supervised, and the records have to be kept. And I just think that and so does the post board, that it's not fair to put an officer out there with 40 hours of training versus 2 years of college and a skills course with technical training in every aspect, from psychological training and training on the range and things like this. So I think that we can be proud of our Minnesota police officers or peace officers and continue on this professionalism by this action. So I'd appreciate a green vote. Should I offer that amendment now, the A1?
We already did, Representative Cornish. Any discussion to the A1? Seeing none, all those in favor of the amendment, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2654 as amended.
Third reading as amended. Discussion to the bill. Any discussion to the bill? The member from Washington, Representative Schoen.
Thank you, Madam Speaker and members, and thank you, Representative Cornish, for bringing this bill forward and addressing the concerns in there from around Minnesota. I urge my team to vote green as well.
Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 97 ayes and 26 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 1851. The clerk will report the bill.
House File 1851, the first engrossment, an act relating to public safety.
The member from Washington, Representative Kiefer.
Thank you, Madam Speaker and members. This bill I've been working on with MnCASA for 4 years now. We've rewritten it 3 times and tried to address all of the concerns of potential unintended consequences by increasing a penalty on a repeat 5th-degree criminal sexual conviction conduct. The bill itself will give county attorneys and prosecutors just another tool in the toolbox to address problems that can oftentimes grow into bigger sexual conviction problems in the future. I think the bill is necessary, otherwise I wouldn't carry it. I think there's an amendment that we'll address in a moment, and I want to just reiterate that this addresses repeat convicted offenses. So keep that in mind, and we'd be happy to answer any questions. Thank you.
There's an amendment at the desk. The clerk will report the amendment.
Paymar moving to amend House File 1851, the first engrossment as follows. The amendment is coded 265.
The member from Ramsey, Representative Paymar.
Madam Speaker, that's my amendment. I'd ask for a roll call vote on the amendment.
Representative Paymar requests a roll call. Seeing 15 hands, there will be a roll call. Representative Paymar.
Madam Speaker, this amendment, actually, we've seen it before. It was in the bill that was submitted by the minority in their supplemental budget bill, the alternative bill, and there were 2 provisions that were in the public safety component, one on the Department of Corrections and then the Keeper bill, which I've been supportive of for so long, and she has worked so hard on this bill, and all that this amendment does is this increases the maximum imprisonment from 10 to 12 years, the amendment does, and also provides a look-back period that prosecutors can look back into the criminal background of the offender to 15 years. So I think that the amendment, I think, enhances the bill
and I really want to applaud Representative Kiefer for her perseverance on this, because these are not minor matters. These are sexual assaults that are happening, and unfortunately with a fifth-degree crim sex assault, they can happen over and over and over again, and this provides an opportunity, A, to get these people into treatment after their first offense, but if they continue violating, then the prosecutor can then charge that as a felony, and I would urge support of the amendment and the bill.
Discussion to the amendment. The member from Hennepin, Representative Loon.
Thank you, Madam Speaker, and members. I also want to thank Representative Kiefer for her very dedicated work on this important bill, and I rise in support of the amendment. As folks will recall, Representative Dowd did offer this as part of an amendment to the supplemental bill. It was very important. I think our side of the aisle gave that very strong support, but not so much from the other. So I'm glad it's going to be something that everyone hopefully will be voting for, because getting serious about putting these folks away who have gotten away with repeated crimes of sexual assault needs to be stopped, and this is a very important step in that direction. So I urge member support.
Any further discussion to the amendment? Seeing none, the clerk will take the roll on the amendment. The clerk will close the roll. There being 123 ayes and 0 nays, the motion prevails. The amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 1851, as amended.
Third reading as amended. Discussion to the bill. Seeing no further discussion, the clerk will take the roll. The clerk will close the roll. There being 123 ayes and 0 nays, the bill is passed as amended and its title agreed to. Motions and resolutions. Is that right? You want me to do that? Yep. Report from the Committee on Rules and Legislative Administration.
Report from the Committee on Rules and Legislative Administration. Murphy E. for the Committee on Rules, pursuant to Rule 121 and 333. Designates the following bills to be placed on the calendar for today for Wednesday, April 30th, 2014. House File numbers 3043, Senate File number 2736, House File 3238, Senate File numbers 2782 and 2390, House File numbers 3219 and 2566, and Senate File numbers 2066 and 17.
Motions and resolutions. There are copies of the non-controversial motions at the House desk and online. If there is no objection, we will take action on those matters first. Hearing no objection, the motions prevail. Announcements. Member from Hennepin, Representative Loon.
Thank you, Madam Speaker. Members, this is just a reminder. Tomorrow is going to be our first of two Love to, or Legislators Uniting to Volunteer events. Tomorrow morning we are traveling to Higher Ground, a homeless shelter operated by Catholic Charities in Minneapolis. Email's gone out with the location, driving directions. If members want to carpool, we'll leave from here, from the State Office Building, around 8 a.m. Staff is welcome to participate as well.
And I would now call upon my co-leader in this effort, Representative Ward. I forgot my T-shirt today, but I'll remember it tomorrow. So he can remind everybody about the attire for tomorrow and other details. Thank you.
Member from Crow Wing, Representative Ward.
Thank you, Madam Speaker, and thank you, Representative Loon and members. This is a great opportunity to come out and make a difference. And I've got the shirt on that we're going to be wearing tomorrow, so dress casual in the morning and then bring your business attire to change into once we get back to Capitol. But it's a great opportunity to show that put our actions, our words right into action. So thank you, Representative Loon, for setting up tomorrow and then next Tuesday also. So please get registered. Let us know how many people are coming. It looks like we have somewhere around 15 to 25 at this point. So get up, get out, and let's go make a difference. Thank you, Madam Speaker.
Representative Sanders.
Thank you, Madam Speaker. Would the Majority Leader yield for a question?
She will yield. Representative Sanders.
Thank you, Madam Speaker. Madam Majority Leader, I know the State of the State is coming on Wednesday. Do you have an outline for the day as far as times for session, caucusing, those sorts of items?
Representative Murphy.
Thank you, Madam Speaker and Representative Sanders. We will be in session at 10 o'clock on Wednesday. DFL members, we intend to caucus at 9 a.m. on Wednesday prior to the floor session. And I hope and anticipate that will be done around noon on Wednesday. And then we'll recess and come back in the evening in time for the State of the State address.
Representative Sanders.
Thank you, Madam Speaker. Would she continue to yield?
She will yield. Representative Sanders.
Thank you, Madam Speaker. Madam Majority Leader, do you have an outline for the rest of the week, Thursday, Friday? Do we know what time session will be? And then on Saturday, is there a session scheduled for Saturday?
Representative Murphy.
Thank you, Madam Speaker and Representative Sanders. On Thursday and Friday, we will come in at 10 o'clock. DFL members, we will caucus at 9 o'clock. And at this point, I do not anticipate a Saturday session.
Representative Sanders.
Thank you, Madam Speaker, and thank you, Madam Majority Leader.
Representative Murphy.
Thank you, Madam Speaker. Members, I move that when the House adjourns today, it adjourns until 12 noon, Tuesday, April 29th, 2014.
Representative Murphy moves that when the House adjourns today, it adjourn until 12 noon, Tuesday, April 29th, 2014. All those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. Representative Murphy.
I move that the House do now adjourn.
Representative Murphy moves that the House do now adjourn. All those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The House stands adjourned until 12 noon, Tuesday, April 29th, 2014.